I am Netta Sagafi. I am Vice Chair of BHBA's Litigation section, and I am delighted to introduce our speaker, Tony Ross, today. Tony Ross became a lawyer because he has always had a strong sense of fairness and a desire to serve others. During law school, he was the assistant to the president of the American Civil Liberties Union, which gave him a front row seat in the fight to preserve and defend the civil liberties enshrined in the Constitution's Bill of Rights. Tony attended New York Law School and attended Rutgers University, where he received a BA in psychology and economics. After law school, Tony embarked on a successful career as an entrepreneur in the hospitality space, and he credits the success of his company to his ability to connect with people from diverse backgrounds. Tony focuses his practice on transportation and general liability matters. He has extensive experience in general liability, commercial litigation, personal injury, consumer protection, and business litigation matters. And now let's get started. So nice to have Tony with us today. Thank you.
Thank you, Netta. Good morning, everyone. Welcome to this presentation on defending depositions, which I think is a good perspective. Often we look at depositions just from the perspective of taking them. So talking about defending them is important as well. I think I've done hundreds of depositions. I actually don't know how many I've done. But defending is important, times more important, but definitely as important as taking them. We can go to the next slide, please. And these are just the objectives of our talk today. Preparing your client for deposition testimony, make sure you preserve your objections, particularly your privileges, avoiding waiving the privileges and avoiding sanctions, which is important, and maintaining professionalism, very important. Next slide. So when you're preparing your client, there are some very key golden rules, we'll call them. Clients, first of all, you have to remember that your client most likely has never had their deposition taken before. So you'll have to manage some of that, some of the anxiety around the process. And different people obviously will have different ways of managing that anxiety. Sometimes they'll want to speed through the deposition. Sometimes they have seen television shows, and which gives them a false sense of really what a deposition is. Because usually on television there aren't depositions; they just talk about them, if at all. And so, first thing you want to tell your client is that this is a marathon, not a sprint. So they should, before answering, don't just run headlong into an answer. Your client might think that they can understand, or they know where the attorney is going, so they try to help them out sometimes and answer the question quicker than is necessary. And that often is not good for making a good record. So you want to ask your clients to pause before answering. That gives you a chance to make any objections. It also gives your client a chance to kind of think about the answer to the question. And you want to make sure that they know that they can estimate an answer. Sometimes there'll be a question about distance or time or height or even a date. They can give an estimate, but they're not to guess. It's very important that they don't guess. ATFQ is answer the freaking question. That's a really important part of depositions. One of the things that I start off with my clients is checking to see that they understand this point. One of the things I'll ask them as an example is, do you know what time it is? And more often than not, they will answer with the time. That is not the right answer. I ask them if they knew what time it is, not what time. Answering the question is important. So if I ask you, do you know what time it is? You can either say yes or no. If I ask you what time it is, then you'll tell me what time it is. That's an important distinction because that's how witnesses get tripped up in depositions by answering a question that they thought they understood. They didn't pay attention and they answered the wrong question. The other thing that you want to make sure your clients understand is to give short answers. The shorter the better. I tell clients that if I ask the question, remember, this is from the perspective of someone who's defending a deposition. ask the question of my witness, they can take as long as they want to give me a long answer because I pretty much know where I want them to go. More often than not, they're answering questions from opposing counsel. Their answers should be short. Yes or no would be great, but those aren't always possible. But the shorter, the better. Another guideline I tell my client is if you are answering a question and you find yourself taking a breath so that you can continue your answer, you're probably saying too much. Answers should be short because that allows you to limit the record. It also keeps them from answering a question that wasn't asked, for example. The other thing is to let them understand they can take a break if they need to. This goes back to the concept of, again, this being a marathon and not a sprint. Most depositions can take several hours, and you can take breaks during that time period, as long as there's no question pending. And you can use those breaks strategically. You can talk to your client. Sometimes the client just needs a little moral support during a break. You're doing really well. You answer that question properly. That kind of thing. You can also, during breaks, your client, was there something, maybe you'll either recognize it or you'll ask your client, was there something that you thought you wanted to say and you didn't say it correctly? Or maybe you'll recognize that a question threw them off and you'll say, was that, did you say that right? Or did you get the information that you wanted? Because you can come back from a break and redirect your client and get a better answer out of them if it wasn't the answer that you think you needed for that, for the record during the deposition. So take breaks, use them strategically. Also, make sure your client understands that you can't coach them during the deposition. They don't often understand that. And for the most part, you're really kind of a fly on the wall in many respects. As we go forward, you'll understand and you'll see what I mean by that. Next slide, please. And this is just, I put some slides in here just to kind of make points a little bit more understandable, at least more indelible. And this is one of those where, this is what clients often do. They'll let me explain everything. No, you don't want them to explain everything. You want them to take the time, answer questions quickly, well, not quickly, answer questions in as short as possible, understanding the question that was asked, and then we'll move on. Next slide. So again, answer only the question that was asked. Do not volunteer information. So you should make sure that your clients understand that the more they volunteer, the longer the deposition is going to be. Answering with people's names. Now, sometimes you can't get away from this. If someone asks, were there witnesses to the car accident, you have to be on, answer truthfully and let them know that there were, if there were, and who they were. But in terms of just, telling a story, so to speak, this is not the place for your client to tell their story. They should not forget that opposing counsel is not their friend. They're an adversary. One of the, everyone has their different ways of deposing witnesses. And my style is that I'm conversational. And you will find that, if you're conversational with witnesses, they forget that they're in a deposition if you do it right. And it feels like a conversation to them. And so sometimes I will just pause after my question or after their answer, and I won't ask another question. And sometimes, often, because it feels like a conversation, they will add more information and answer a question that I may not have asked. So you want to make sure that they know this is not a chance to tell their story. They should not forget that opposing counsel is not their friend. And don't volunteer excess information. Do not give, excess or unnecessary explanations. Really, if you've done it right, and you should probably be prepping your witness several times before the actual day of the deposition, they should have, heard several different types of questions. And you should, ask some of those questions should be hard. Some of them should be somewhat tricky so that they understand. That they have to listen to the question asked, give you a short answer. Don't give unnecessary information. Volunteer anything. The thing that I often say to a witness is that opposing counsel is entitled to your best recollection and your best testimony. They are not entitled to, the ruminations in your head. If you're not careful, your client will go, okay, that was a Wednesday. And on that Wednesday, I had this for breakfast. And then I went to the gym and then I did this and then I did the other thing. Oh, and then I had the car accident. And then that is a lot of information that is not necessary. And a good opposing counsel will take that information and ask questions about it. It helps them to determine when a story is true. But it also helps them find out more information about the circumstance issue in the deposition. So again, it's very important that they don't guess. That they can give an estimate, not guess, and keep their answers short. Next slide, please. Guessing versus knowing, really should say estimate, guessing versus estimating, but it's the same concept. So again, no guessing, just estimates. And I don't know is a perfectly good answer to a question if it's true, of course. I don't recall or I don't know, the way those mean two different things. I don't recall means that I did know, but I don't know right now. And I don't know, it means I never knew. I don't know. I have no idea. I don't know the answer to that question. Both of those are acceptable as long as they're true. So, encourage your client, if they don't know something, there's no reason for them to make up an answer or to speculate. If you don't know, you don't know. If you don't remember, you don't remember, and that's fine. Please. And again, answer the freaking question. So this is, I put this slide in again because it's really important because, in the moment, again, remember your client has never been deposed, likely never been deposed before. Even with good preparation, they may get a little nervous or anxious during the deposition. And again, they'll refer, or it might be, that your opposing counsel has a very conversational, and your witness just starts talking, even when there's no question pending. And that's, by the way, another way to interject is you can actually say to your client, okay, there's no question pending, which is a cue for them to stop talking. So just make sure the client knows that they answer the question, only the question that's asked. They don't have to give long explanations. Just answer the freaking question. Thanks. So when defending depositions, it's not the same as when you're objecting in court. Most of the objections in a deposition are you have to make the objection to preserve them, some of them, for later for the court in case something comes up where you definitely want to interject the objection, your objection. But during the deposition, almost everything is fair game. We'll get to the privileges shortly, but most questions, the standard is that to be reasonably likely to lead to admissible information. So it doesn't have to be relevant in and of itself, but it could lead to something relevant. So relevancy, objections, again, that'd be an objection to form. And so when you have objections to form, that's what you say. You can say objection or objections to the form of the question. You don't have to go much further than that. And most times it's bad form to go much further than that. Sometimes people say objection relevancy or objection asked and answered. Again, those are form objections, and the proper way to do that is objection to form. And that's it. You're not at that point, you're not instructing your client not to answer the question. That would get you sanctioned under those circumstances. If the question is asked and answered, okay, been known to ask questions several times from several different perspectives because you want to test, your witness. Sometimes you're testing to see if they're going to give you the same answer. Sometimes they give you a nuanced answer, or they'll give you more information if you ask the question, slightly differently. So with objections to form, that's all you really get as the attorney defending the objection is objection to form. That's it. Now, when you get to privilege objections, those are different because objections that are not stated on the record are waived. So that's why you're saying objection to form, because if it is a relevancy objection or some other type of form objection, you're saying objection to form so that if it comes up later before the judge, you can say, yes, I objected, and this is why. Well, with privilege, those objections to be on the record right away. Objection, attorney-client privilege, that you instruct your witness not to answer that are privileged. Because if your witness violates a privilege, then it's waived. So you don't want to have your client waiving objections. And there are very few privileged objections, and we'll get to what the rest of them are. But the most important one is, of course, attorney-client privilege, or maybe work product. It doesn't come up as much as attorney-client privilege. But you want to make sure that you tell your client, you instruct your client. And again, this is done during your prep. Tell your client, if I say objection, attorney-client privilege, if I instruct you not to answer a question, I'd like you to, honor my instructions and don't answer the question. I often tell my client it's unlikely that this will happen, but it may happen, and just prepare them. If I instruct you not to answer a question, do not answer the question. All the other objections, the client will be confused because he or she will hear the objection and they'll be wondering, oh, can I answer? Yes, they can answer and they should answer, but only if it's not an objection, a privilege objection, in which case you should instruct your client not to answer. And that is well within the rules. There's no judge that would fault you for that. Objections to form, if you're instructing your client not to answer those questions, you could get sanctioned pretty nastily from the judge. Next slide, please. So again, just don't waive privileges. Any client privilege, there's patient privilege. There are certain things that are privileged that you will want to preserve on the record. Otherwise, it's waived. And here are your privilege objections. Your attorney-client, there's work product privilege. Again, that doesn't come up that much in a deposition, but it is there. There's the medical privilege or doctor-patient privilege. They may ask you, the injury or the issue may have been a car accident, which is why the client is being deposed. But the question may come from opposing counsel, when did you get pregnant? Not relevant, and that's a medical privilege that you might want to preserve for your client. I would instruct my client, of course, as long as that's not relevant to the actual issue that they're there further at the deposition. I would instruct my client from things that are medical not to answer those questions. And most times, opposing counsel will understand that. If it's very far afield, particularly if it's of a personal nature, it's a medical privilege, I would object. And you can also use the privacy objection for that as well. If the person may have mental health issues, but those are not at issue, in the injury or the accident that you're is being deposed for, you would raise a privacy privilege or a doctor-patient privilege under those circumstances. And again, most times, a judge wouldn't sanction you for those type of objections. As long as it's a privilege objection, you're pretty good to instruct your client not to answer. That doesn't happen. It happens a lot on television. It does not happen that much in an actual deposition. Next slide. So you want to avoid frivolous objections, and again, a frivolous objection is many of the objections we just talked about. Relevancy, hearsay, asked and answered. Again, objection to form. But frivolous objections, they harm your credibility because you don't look like a good attorney. You look like you're defensive when you don't have to be. Let the testimony stand for what it is. If it's a dumb question, okay, it's a dumb question. Just let it go. Don't object for reasons like that. You can get sanctioned for that. It makes the deposition take a lot longer, and it's unprofessional. So for the most part, you want to avoid any of those objections that would be considered frivolous. And again, you can get sanctioned for those, and it's just bad form. So a speaking objection is an objection where you're really explaining yourself. And oftentimes, they're considered to be coaching your witness, which you're not allowed to do during a deposition. So if you know that the question, whatever the question is, it's kind of a trick question, and you really want your client to answer it one way or another, if you haven't prepped them for it, at least in the moment, you're out of luck. They're going to answer the way they're going to answer. You can't interrupt with an objection, and try to coach them as to the best way to answer that question. That's really bad form. I wouldn't take it in the deposition. I would stop you and admonish you during the deposition. and stop the deposition if you continue to do it. Attorneys are a little bit more forgiving. It depends, but you don't want to do speaking objections where your objection, that's over, that's outside the scope and blah blah blah. You don't want to go through explanation. You shouldn't have to explain. You object on form, which is mostly what you're going to do, and then if you've prepped your client properly, just let them answer the question. Remind you, as we said, about taking a break, right? If they answer the question and there really is a bad answer, when you take your break, instruct your client, hey, remember we talked about this, this is what you should have said when you were asked that question. You'll have an opportunity to ask questions at the end of the deposition, and you might tell them in advance, I'm going to ask you that again, and see if we can get a better, answer it the way we practiced it. That's how you would cure an answer that you weren't really happy about during the deposition, but you don't want to do a speaking objection. They're really kind of rude. They're annoying. So you're extending the length of the deposition, and it really just it's bad form. Any way you cut it is bad form. So no speaking objections. Next slide, please. And it's just a slide to kind of bring the point home. Don't explain. Just do objection to form. I think I might have put this in the slide as well, or just in the presentation. From the other perspective, if someone's objecting to your questions, okay, just move forward. You don't have to respond to the other person, opposing counsel, when they object. Move forward, but no speaking objections. Next slide, please. Another example of that, and again, just objection to form. 2 words. It's very simple. Anything beyond that, it's kind of similar to what I was saying about if your client finds himself taking a breath as they finished an answer, they're probably talking too long. Same for you. If you're defending your client and your objection is you're taking a breath to continue your objection, it's highly likely that you're doing a speaking objection, and you really don't want to do that. So these are the objections to form. There are probably some other ones, but these are the most common. So the leading question, objection to form, compound question, those come up, where they ask the question, but they're asking 2 or 3 different questions. Was it dark outside and was there a light on? That's a compound question, objection to form. If the question is vague and ambiguous, objection to form. The cause for speculation, objection to form. It's argumentative, same thing, objection to form. Now, I will say that sometimes during prep, I will let my client understand, or at least try to get them to understand, certain objections I am kind of signaling to them. It depends on the sophistication of your client, if they can grasp this. Sometimes, and oftentimes they can. If I say objection argumentative, that's kind of a clue to my client. Don't fall for that. Objection vague and ambiguous. You're not going to do this a lot, but you might. That's a cue that, okay, something's wrong with that question. If your attorney is not understanding it, maybe you need to think about it a little bit before you answer. So the objections to form can be, if you make them short enough, it's not a speaking objection if you do it properly. So you can use them strategically if your client is savvy enough to let them understand, hey, if that's cause for speculation, that means, I should think about how this question more carefully. And a good witness, if you've prepped them properly, will understand when they hear those objections and say, okay, that takes a little bit more of my attention. Make sure I answer it properly. You should also, during prep, make sure that your client understands. They can ask for a question to be restated so that it's clearer. Oftentimes, opposing counsel will ask a bad question. I do it all the time. You ask the question, then you realize, oh, that wasn't the best question. But if your witness answers it, okay, it's kind of a freebie sometimes. So let the witness know as you prepare them for deposition that they can say, hey, could you restate the question, or could you ask that differently, or I don't understand, because they'll learn. You'll prep them in this way, but also the admonitions at the beginning of the deposition. They're instructed to understand that if they answer the question, an answer is an assumption that you understood the question. So it's much more difficult to answer the question and then later on say you didn't understand it, as opposed to just during the deposition say, hey, could you restate that? Could you ask that question differently? I'm not sure I understand. Much better way to go. Next slide. Oh, and this is my problem. I talk too fast. So the fast talking opposing counsel, this really can mess up the record. Same goes for the witness. Everyone has to learn to slow down. I constantly tell myself that. Slow down. The court reporter will thank you for that because the court reporter is taking down everything that is being said, everything that's being said during the deposition. And they can't take down everything when people are talking at the same time. There is a part skill, part art in depositions in the cadence and understanding, when a person is finished with their answer or their question and when you can speak. And you will find that there are witnesses and opposing counsel who get that wrong all the time. They don't know when you're finished. They start talking before you finish. Those mess up the record. And so you don't want to talk fast. You want to take your time, whether you're defending or taking the deposition, and you want to instruct your witness that they should understand slowly, don't rush, be clear, and take your time so that the record is very clear. Next slide. So the pace of the deposition. Pace of the deposition. Watch for rapid fire questioning. So one of the techniques that works, at least works for me, is you get into a routine. So you might say, some very short questions at the beginning before you ask a question that would take some nuance to answer. But if your witness gets into a routine, into a rhythm with you, they will often answer questions quickly without thinking about them. And that can hurt you if you're defending the deposition. So you want to make sure that there's a very slower cadence to the deposition itself. And you can be strategic with your objections in that respect as well. And what I will do is if, there's opposing counsel is asking questions and your client is answering them almost rapid fire, I might let that go on for, one or two questions, maybe three questions, and then I'll object. Just say objection to form. The real purpose, though, is to interrupt the cadence, is to interrupt the routine. Because again, witnesses, handle depositions different ways. If they're nervous, they may just talk quickly. They may want to get finished with the deposition and assume, wrongly often, that if they just answer quickly, then this will all be over. They can answer quickly and end up, really doing some sabotage to the case because they're giving the wrong answer or an answer that's not as helpful to your case. So you want to watch the cadence of the deposition. If it seems like it's going, your witness is answering, really rapid fire, really easily, and it looks like they're not paying attention to the actual question, object. Again, you can't coach them during the actual deposition, but if you're strategic about your objections, sometimes it just slows everybody down. Then you might want to, let them answer the question. They'll have to, and then you might want to ask for a break at that point, so that you can remind your client, you need to slow down. You're answering these questions too quickly, and you're not paying attention. And that also ensures the clarity and accuracy of the record. It is not uncommon for an attorney to ask a question several times because they're looking for a certain type of answer that will help them in their case. So, and there's nothing wrong with that. So, if you instruct your client properly, they're not just shooting off answers very quickly without considering what that might do in terms of their credibility and clarity of the record. And they're not going to be able to understand some of this because they've never been deposed before. Your job as the attorney to prep them, as well as you can. But you're looking as a person defending the deposition. Your job is to pay attention to what the question was, how quickly it was answered, what the consequences of that question are. You should be taking either notes, as to what you need to, where you need to redirect your client because of the answer, where you need to instruct your client, to go back on the record and clean up an answer that wasn't as clear as you need it to be. So you don't want to watch the pace of the deposition, slow everybody down, object strategically when you need to. So this is, the hostile interrogator. These are the attorneys who think that, their job is to be rude, either to your client or to you. I often tell my client, don't take the bait. Oh, I always tell my client, don't take the bait. And I also tell my client, my job is to be, if I need to be, is to be, the pit bull, or to protect you and defend you during deposition. I instruct my clients to always be respectful, answer politely, even if they think that the opposing counsel is being a jerk. They are to answer, with respect. It's my job, or your job as the attorney defending, to defend your client. And you can object under the circumstances when your client is being badgered. I think next slide. So if your client is being browbeaten, sometimes opposing counsel will ask questions quickly because they want to get through with the deposition for some reason, or maybe that's their technique and their style. You want to slow that down because it feels like to you, maybe it feels like they're bullying your witness. You don't want that. And you can definitely, object based on bullying your witness or being argumentative if they really are. It has to be egregious. I mean, of course, litigation is adversarial, right? So sometimes you or your client may not like the question that was asked. It doesn't mean it was an improper question. It doesn't mean it was bullying or harassing. So be strategic about this as well. But stand your ground. Make a clear record. If opposing counsel is unprofessional, you might want to say that on the record because remember the transcript. There's no nuance in the transcript. You can't get necessarily. You don't get tone of voice in the transcript, right? So you might want to say, objection. Please don't yell at the witness because if you don't say that, there's nothing in the record that would let someone know who's reading the transcript that the opposing counsel was raising their voice. So if something like that happens, that you want to make a record of that. You can seek court intervention, but that's really a last resort. If you don't know, you will learn that judges really hate discovery battles, which includes deposition battles. So you don't want the judge involved unless there absolutely is no other way to do that. So there are probably, think of it in terms of tiers or stages. Where if you're at this point in a deposition and the opposing counsel is being harassing or bullying or unprofessional, you might object first. Just say objection to form. You might just start off objection to form. If it happens again, you might object. Please don't harass the witness, or objection. Harassing the witness. Next time, if it happens again, objection. Please don't raise your voice at the witness. And then at that point, I might start informing opposing counsel of what's going to happen next. Objection. If you ask the question, in the same manner again, I may, suspend this deposition. May instruct my client not to answer, because at some point you may have to take control if it's just getting out of hand. Again, these are not things that happen common, that often. So you don't get this at every deposition. You don't get to just, oh, you're yelling at my witness. I'm suspending this deposition. Please don't do that unless it's really important, because you will look foolish and could be sanctioned by the judge. So you want to make sure you're careful about this, but you also stand your ground. You want to make sure you're also don't look look unflappable. Don't let them see you sweat, I think is a common expression that people say. You want to just keep your cool the whole time, even if opposing counsel is unprofessional, because it really speaks highly of you as an attorney. It shows your confidence about your abilities and your confidence about the case. It makes your law firm look good. And then if you do end up before the judge in a discovery dispute, it's very clear to a judge if there's one party that's very calm and the other side is being ridiculous. You don't want to have both sides being ridiculous. Then the judge is really annoyed and may sanction both of you. So again, you will stand your ground, of course. Don't allow your client to be bullied. Um, make a clear record. Make it clear that opposing counsel, you know, you know, you can sit down counsel. There's no reason to stand during a deposition. Things happen in depositions, and there's no, especially if it's not being videotaped. And often, even if it is, because the videotape is on the witness, it's not on the attorney. So if you need to make something clear for the record, you can. You seek court intervention if you absolutely need to, but you don't want to use that unless it's absolute. You have no other option. You can move on. This is the improper catch-all question, is what I was saying earlier about compound questions. These are objections to form. Sometimes the attorney, again, it's not always on purpose, but it could be on purpose, or it could just be a bad question by accident. If it's a compound question, you don't want to let your client answer it because it's not clear on the record which question they're answering. So if they say, and these are often come up because they're written questions in discovery, it's fine to say, state all facts regarding, the issue. That's fine. Or all witnesses that saw, whatever happened. That's in a written discovery. That's fine. But during a deposition, it's not fair to the witness to state all facts and to remember, all witnesses, or identify all documents. Those are things that are unfair, and it's a bad form to ask those at deposition. So it's okay to object, but you object on form, and that's really it. There's no continued objection. You don't speak during doing a speaking objection. It still would be a bad form there as well. Slide. So, as I said, objections to form is fine. Often, when you start hearing about relevancy, hearsay, competence, that's improper objection. People do it, but you want to be the attorney who understands, the code and how to, defend depositions properly. You want to just say objection to form. If you're not used to that, maybe it feels like you're not saying anything, but opposing counsel understands. Now, they don't have to change the question necessarily, but just by saying objection to form, you preserved your objection. If they try to read that into the transcript later during trial, you have an ability to say, there was an objection there, and explain what it was. But again, even if it's there's a objection on competency, or if you're objecting based on hearsay or relevance, those are great at trial, but they don't help you during a deposition. So those are objections to form. That's all you need to say, and that's it. Next slide. So we can go to questions after this, because we're pretty much done with my primary presentation, and I can provide anecdotes as well as answer questions. But key takeaways: good preparation prevents deposition disasters. So you want to make sure that you've met with your client several times, that you've several different types of questions that you've tested them on, and make sure they understand how to answer a question properly, how to listen to the question that's asked and answer only the question that was asked. It'll take some time. How to give you short answers. Again, it should be short as possible. Their answers should be as short as possible, unless you ask them the question. It's safe for them to answer, a long form, give you a long form answer if you're asking the question, because you're going to ask them a question that would elicit a long form answer that's helpful to you. But you don't want that from the opposing counsel. So you want to make sure that they are prepared. They give you short answers. You want to make sure you object properly, and that you protect your privileges, and you want to remain professional at all. These are not things at the beginning. It's not intuitive. You'll have to remember a lot of these things at the beginning, because they're not intuitive. You're remembering to listen to the question that's asked. Just like you asked your client, you have to listen to the question that's asked too, because you should know what the answer is, or at least what you want it to be, and then be able to redirect your client. You should make sure that the answers your witness is giving are short. And if they're not, you want to throw in your objection to kind of break it up. That cadence is get, that conversational cadence in terms between the opposing counsel and your witness. You don't want that. You want your witness to be, you don't want them to be comfortable with opposing counsel. You want your witness to be somewhat circumspect. You want them to think that, oh, every question might be a trick question, so I need to think about the answer. Train your clients to understand that if you object and you say more than objection to form, there's probably a reason that you're doing that. So you can't say much, but if you say object, vague and ambiguous, clue to your client, maybe that was a trick question. So key takeaways I'm trying to get you to think about is that if you're defending an objection, if you're defending a deposition, you want to make sure that you're very limited in what you can do. So you want to make sure that you use your tools properly. Use your preparation really strategically. Your client should have heard every type of question and be prepared to answer every type of question, trick question or not trick question. They should understand that their answers should be short. They should understand when you object in a certain way that sounds different, they should go, okay, be careful about my answer to that. And you should be professional at all times. And then, just a well-defended deposition protects your client, protects your credibility, and it protects your case. Those are the things that you really want to focus on. There's nothing worse than spending 5 hours in a deposition and then realizing when you get the transcript that your client gave a lot of information that wasn't helpful. Your client ruined their credibility by answering, argumentatively, for example, when they should have been answering respectfully, and it can ruin your case. So you want to really be careful when you're defending depositions because, again, most of our focus often is on taking the deposition, which is a whole different skill set. But if you're defending a deposition, it's equally important and often more important how you defend your client, protect them, and protect your record and protect your case. Are there any questions?
Hi, Tony. So it looks like we actually have 8 questions so far within the Q&A
Okay.
box. Starting off with one from Cedar asking, do any of these tips differ when you are defending an expert's deposition as opposed to a client's deposition?
They do, a lot different. And that's a whole different, another different skill set. Expert depositions are a skill set unto themselves. They're so different that we really can't get into them that much right here. But I will say that they are different in that experts are presumed to have a certain level of expertise. You don't protect them the same way that you protect a lay witness. So yes, they're very different. The way you defend an expert than the way you defend a lay witness.
Great, thank you. And I have another question from Richard asking, would a question that violates a protective order be considered a privacy privilege objection that you can instruct your client not to answer? Yes.
I mean, it depends on what the question is, whether or not it's privacy but if it violates a protective order, that's what your objection would be. That's outside the scope. It violates a protective order that's already been put in places on file with the with the court. That's totally valid objection and would be expected that if the question violates the protective order, you would object and instruct your client not to answer. And again, opposing counsel understand that. Sometimes they don't. Maybe the person taking the objection is not a handling attorney, and they may be prepared for the objection, but prepared for the deposition, and not as prepared as maybe the handling attorney. But doesn't matter if it's violating a protective order. Yes, you would instruct them not to answer the question, but you'd also put on the record why you're instructing them not to answer, and explain that there is a protective order around that subject that is being questioned.
Great, thank you. And I have another one from Cedar asking, how do you want your clients and experts to dress? Looking innocent and truthful, conveying gravitas, or experience, calming, confident, or something else?
Good question, because it really depends. First of all, the general rule I tell all my clients, dress as if you were either business professional, or sometimes I say as if you were going to church. You want them to be dressed, professionally, sure. If they're a military officer, maybe you want them in officer dress. It depends on the witness and what the issues are, but you want them to dress well. You don't want them to look like they just walked in from the gym or something like that. But the reason it depends on the witness, though, is because, for example, what if your witness is a CEO of a large corporation, and you want them to convey that they have that they're humble and that they have empathy? You would maybe say to the witness, don't wear a tie. Wear a dress shirt and maybe wear a jacket, but don't wear a tie. So it really depends on the witness and what the circumstances are of the deposition. But you at least want them to dress respectfully and be well dressed.
Right, thank you. And I have another question from James. Can you point to authority that states that objection to form is permitted and you are not required to state any more than that? I was criticized recently by the court for objecting to form only, and a new deposition was compelled.
It's interesting. I'm very curious as to what you did that. So you were criticized for objecting to form, but trying to think of the statutes. I'm actually looking to see what I have in terms of my my notes here. So I may have to get back to you because I don't remember statutes off the top of my head, but I may have to get back to you in an email. So by all means, you can email me at tony.ross@wilsonelzer.com. But trying to see if let's go to the next question. At the same time, I'm going to look to see if I can find the statute that helps you with that.
Great, thank you. And then I have someone asking if relevance is an improper objection.
It's improper, yes. The short answer is yes. But if it's so irrelevant, so far afield, it might end up being a privacy objection or a doctor-patient privilege objection. Relevance by itself is a bad objection. You can object to form, but that's all you get. But objections to form, remember, objections to form don't stop the deposition. They don't stop your client from answering the question. They just preserve the objection. So if it's a relevancy objection and you say objection to form, relevancy, or objection to form, that's fine. That's all you would get. You don't get to tell your client not to answer because it's not relevant, unless it's way far afield. But those are rare.
Thank you. Another question. What
Sure.
is the authority for only saying objection as to form rather than slightly more specific, such as objection compound or objection vague as to time?
Again, it's objection to form is considered the cleanest and the most respectful way to do it. You can say those other things, and often people do. Sometimes you do that because you're also reminding yourself. When you go back and look at the transcript, you want to remember why you objected. And sometimes you're signaling to opposing counsel. If you say objection to form, let's say opposing counsel is a relatively young attorney, you might say objection compound. That's an instruction. Essentially, you're letting them know there was more than one question in that question, and that may help opposing counsel. Whether they listen to you or not is up to them. So that's why you would say it. It really depends on maybe the sophistication of the opposing counsel. Because objection to form, I will say objection to form when I know that the other side is very sophisticated, and there's no reason for me to get more granular than that. But sometimes you do want to say objection relevancy, objection compound, objection asked and answered. Again, you can do that. And for the question that was asking that's earlier about the authority, and he may have been saying, he said he was sanctioned because he only said objection to form. If there are only objections to form and there's never ever an explanation, it may look to a judge as though you're just you're obstructing the deposition. And so again, some of this stuff is art versus skill, because I object to form all the time and I've never been sanctioned for it. But also I'm doing that based on the totality of the full deposition. Like I said, if it's a very sophisticated opposing counsel, I object to form and they understand. Everybody moves on. They may restate the question in a better form. But if the question is compound, if the question is let's say they say tell me, was the light red, and the car was coming, and the witness, and the pedestrian was in the street, that's a very compound question. And they ask it several times, you might want to say objection, compound. You're asking 3 different questions within. That's not really a speaking objection. It is, but you're trying now to be clear to opposing counsel why you're not, why you may have to instruct your witness not to answer. Again, these are rare, But if you're saying objection to form and nothing changes, um, but the question is so bad that you really need it to clear it up for the record, you may have to be a little bit more clear about what the form objection is. It may be more more art than skill sometimes in the objection, but objection to form, generally speaking, is totally acceptable. You don't have to go much further than that, but sometimes you do.
I have another question. If you can elaborate a little on address preparation for video depositions.
So the preparation for video depositions is almost the same. The difference is that you want to remind your client that they're on camera. So facial expressions obviously come through on camera. If they're rolling their eyes, if they look bored, if they look mad, those are things that you definitely don't want during a video recording deposition, because that's, could be used against you. This day and age, especially after COVID, it used to be that almost always depositions were in person. You go to the office of the opposing counsel, or they bring the witness to your office, and everyone's in the same room. Even when they're videotaped, everybody's there. But when you went to trial, you can object. Often people would want to introduce the video of the deposition, and you could object because the witness is available, the witness is here. There's no why use the videotape? Have them answer the question on the stand. Not as common anymore. Oftentimes now, almost all of the witness testimony can come through during the deposition. And so if that's the only chance that the jury is going to see either your client or the witness, you definitely want to know that they're putting their best foot forward in a video deposition, because that may be the only way that the jury sees them. So you want to make sure they're dressed appropriately. You want to make sure that they're not disrespectful. They don't get angry. They don't look bored. There are all kinds of depositions available on the internet, and I encourage people to go check them out, because there are lots of depositions, videotape depositions that you can see online, and you can see just by watching the video why that's a bad deposition. I don't know if have you ever seen some of Donald Trump's depositions that have been videotaped. He can be really, really combative and answer depositions really hard and answer questions really horribly. That wouldn't necessarily come across if it was just the transcript you were reading, but when you see his facial expression or hear his tone of voice, it looks bad. So you want to be careful with videotape depositions, and most depositions are videotaped nowadays.
Great, thank you. And I have someone who is asking, what if the questions go beyond what is alleged in the complaint?
So that's a relevancy outside the scope. Also is how you would look at that. Again, if it's remember the standard is if it has to be reasonably likely to lead to admissible evidence or admissible information. So it can be outside the scope and still be within the bounds of a deposition question. And almost all questions at deposition are fair game. That's why it's rare that you would be instructing your witness not to answer. So you'd have to kind of monitor it. Let's say the first question, it depends on how far afield, right? You could maybe let the question go if it's outside the scope, it's a little far afield, but it's no harm, no foul, right? But if it's really, how often did you beat your wife? And this is a question about, a car accident. An issue about is the car accident why you're being deposed. That is so far outside the scope that you would object and say how, relevancy, privacy, harassing the witness, argumentative, and I might instruct my client not to answer that question. Is there a reason why you're asking that question? You might ask the opposing counsel on the record why they're asking that question if it's so far afield. And depending on the answer you get, you can make, you would say, I'm sorry, counsel, but I'm going to have to instruct my client not to answer that. You want to be on solid ground if you do that, because you'll get sanctioned, or you could get sanctioned anyway. You're not right. But sometimes it's so far afield that you have no choice.
Great, thank you. And then I have a similar question. How do you address questions around a prior confidential global settlement agreement by the opposing attorney?
So that's kind of similar to protective order. So there are different ways to do that. You might say to, you might object on relevancy, or you might say there's a protective order. I mean, well, it's confidential, and you can say that on the record. Sometimes you might ask to go off the record and have a discussion with opposing counsel off the record about that question. Maybe they didn't remember, maybe they did not know. It might be they're not necessarily trying to get away with something. They didn't know that there was a protective order around the answer to that question. And so sometimes that's how you'd handle it. But you definitely don't let your client answer it if it's something that's confidential.
Thank you. And then let's see. We have a question from Brad. What if an attorney is being deposed in a civil claim that he is a How should he dress for deposition?
Ask that question again, please.
All right. What if an attorney is being deposed in a civil claim that he's a plaintiff? How should he dress for a deposition?
I mean, again, they should always dress like they're business casual, or sometimes I say, like I said, as if they're going to church. It really wouldn't matter whether they're a plaintiff or just a witness. You don't want them to look sloppy. You want them to look credible. Consider how you would look at a person, whether you would find their answer to be credible, depending on how they dress. And so you want to have your client portray themselves in a way that a jury would accept their answer and accept them as a credible historian as to what they're answering about.
Great, thank you. So it looks like Rogelio Ruiz is asking, my understanding is that the grounds to justify leaving the deposition is narrow. What are the grounds to leave the deposition?
They're very, very narrow. So again, the grounds would be, harassing questions that are really far afield, or really, again, egregious. If the opposing counsel is calling your witness names or calling you names, sustained yelling, God forbid, being profanity during the deposition questioning. It's really it would have to be really egregious to suspend the deposition. It's very, very rare. I don't think can't remember ever suspending a deposition. Now you can threaten to suspend a deposition. Sometimes that's all you need to do. And again, sometimes you go off the record. Sometimes you can have a discussion with opposing counsel and maybe calm things down. I don't think I've ever suspended a deposition for real. I may have threatened it once or twice, but I've never really done it. It's really, really rare. And again, opposing counsel usually understands the consequences and circumstances as well. You don't want to be, and I definitely have seen this. I've been in depositions that were suspended improperly, not by me, but by another attorney. You don't want to be that guy or that gal. You don't want to be the person that suspends a deposition prematurely and then gets called on the carpet by the judge or by your partner at a firm. You get called on the carpet by your partner. So you don't want to do it unless you absolutely have to do it. It has to be because attorney-client privilege is being insisted upon. Badgering the witness, really unprofessional behavior. Those are usually the circumstances where you would suspend a deposition.
Great. And it looks like we have just 2 questions left. First one is, when there's a single question based on several facts, is objection compound improper?
No, it's not improper and it's necessary. So it is an objection to form, but if you're really trying to signal opposing counsel because maybe they don't realize the question is compound, if that's the case, no, it's proper to object if the question is compound, and you want to protect your witness because you don't want them to answer a compound question because then it's not clear what question they're answering. So it is proper and necessary to object. And again, if they do answer because the opposing counsel either doesn't get the memo, so to speak, then it is what it is. But you then take advantage of it later on. When opposing counsel tries to use that answer, you might point out, I objected. It's a compound question. And so I'm not sure that, that question, the answer is, means what the opposing counsel thinks it means. And that would be the opposing counsel's fault for asking a bad question. But you do want to object if it's compound, yes.
Great, thank you. And our last question from the Honorable Victoria Cheney. How do you handle how do you handle secret coaching on video, such as texting between the attorney and the witness?
Good question, and that's really important. So a couple of ways to handle this. These issues came up because, again, pre-COVID, everybody was in the same room. And so you could usually see what was happening, even if someone, if opposing counsel is sitting next to their witness and passing notes back and forth. That's improper. If I see something like that, depends on how egregious it is. So you might want to give a warning first on the record. Remind everyone that that you can't coach a witness during a deposition. But one of the other things that you can use, and I have definitely used this, anything that a witness brings into the deposition is discoverable. So if a witness is, looking at a cheat sheet, for example, that they either have in their pocket or they maybe have, a legal pad in front of them that actually has some, answers to questions that they anticipate, you can ask for a copy of what it is they're reading, what it is they have on them. I often instruct my clients, do not bring anything. I often tell them to leave their phone somewhere else if we're doing an in-person deposition, because even if they bring their phone, you may be entitled to something that's on their phone, depending on the question and the circumstances. So one, you do a warning. I would do a warning on the record, remind opposing counsel there's no coaching of witnesses. And you might want to do that once or twice, but you are entitled to anything that the witness is reading or referring to during a deposition. And I have insisted on of what the witness was reading turned out to be instructions from opposing counsel that they should not have had. You're entitled to anything that a witness brings into a deposition. You're entitled to it. So that's sometimes how you have to go about getting to the bottom of coaching a witness.
Great. So it looks like that's it for questions today, Tony. Do you have any other concluding remarks that you'd like to make?
I don't think so. I mean, I would just remind everyone, depositions can be, they're a great tool to use to find out. You want to, deposition definitely gives you information about the case, of course, obviously. It also gives you a lot of information about the witness. Is this a credible witness? Is this a witness that you can tell? Is this a witness that gives you really honest and clear and concise answers? Depending on what side of the V you're on, that may not be a witness you want. I mean, that may, that can settle your case. If the star witness is clear and concise and dresses appropriately and answers your question clearly and succinctly, and you can't trip them up, you might want to think about settling the case if that's one of the circumstances of what you were looking to determine during the deposition. So it's a good tool to have in your tool belt. You can learn a lot about your case. You can learn a lot about the witnesses. You learn a lot about if there are other issues involved. Maybe you didn't know that there were other witnesses or other injuries or prior similar acts by another party to the case. So you just want to go in, have fun with them. It's like I said, an art and a skill, and if you develop it properly, there are lots of attorneys who. I know lots of attorneys who almost their entire practice is their take depositions because they're so good at it. You can elicit a lot of information. And again, the expert depositions are different. And so that's a different skill set. And it's a lot of fun. And it exercises one of the parts of the brain that a lot of us as attorneys really like to exercise, because it's complex and can be interesting and can be fun and informative. Thank you, everybody, for listening to this presentation. And if you have any questions, feel free to email me. And thank you again. Thank you again.
Thank you, Tony, for an excellent presentation. And thank you
Right.
so much to our audience. Have a great day, everybody.
Thank you.